And this is the Law&Crime Network, for the record. I'm Michael Bryant. We are in the midst of the case in Florida against Mark Sievers. They are on a break. So we're going to do a little something we like to do when we get the chance. We've just finished the Henry Segura case out of Florida, the penalty phase wrapping up yesterday. And so, of course, this is the case involving the death of Brady Peters, her two 6-year-old twins, her 3-year-old, all according to the jury now at the hands of Henry Segura, who was sentenced yesterday to life in prison, actually a kind of a combo of 2 life without parole sentences. Joining me now is Nathan Prince. He is the lead defense attorney for Mr. Segura. Thank you so much for being here, Nathan. I appreciate your taking the time.
Yes, sir.
And I should mention you also had Tiffany Baker was also on the team. You guys worked together on this case, correct?
That's correct. Yes, sir.
So let me just ask you this, and I appreciate the emotion, the passion, and how drained you must be, but I have to tell you that whether on this desk or listening, watching in our audience, guest, they love you. They love your work, they love your passion, you're articulate, and we think you told a great story. And I'm not the only one who thinks you got a raw deal. I'll put it that way. So that may be a little consolation at this point for you or Mr. Segura, but I think it's worth saying. Let me ask you first of all, what went into the decision to get a 6-jury member panel?
Well, last time the final breakdown amongst the jurors was 11-1 in favor of acquittal. And, I was contacted by one of the jurors after the last trial concluded, and she, kind of walked me through and explained what the process was and how it broke down. And once I knew, who the holdouts were, those were individuals that I had identified as people I wanted to strike the last time. I simply ran out of strikes. So the thinking this time was, and of course you wouldn't do this on most murder cases, especially capital cases. But on this case, with the evidence we had, we thought that we would be more likely to avoid a hung jury and get a not guilty verdict if we went down to 6. We thought if I had more strikes than seats, that I'd be able to better control who made it onto the jury and therefore better control the outcome of the case.
Right. And clearly you were happy with the jury that you got. And I have to tell you, when the deliberations ended after 3.5 hours, I just, I wrote it in ink, acquittal. I mean, there's no way they can go over the details and the confusion and the complexity of this case in 3.5 hours and find guilt by even a 6-member panel. How were you feeling when you heard they came back after 3.5 hours?
Well, I mean, my thought process was exactly the same as yours. For the multiplicity of the evidence here, the different types, the different kinds, and just the volume of it, I expected that a decision coming that quickly would have to be a not guilty verdict.
So let's talk about your case. There was not an affirmative defense, but there were alternative suspects, and it seemed, I mean, you had a long defense case. It seems maybe at times the jury might have been overwhelmed by the DNA. What was the decision-making process, and how do you feel about the volume of the DNA evidence in this case?
Well, I mean, I think a lot of attorneys try to play too folksy with complex topics like that. And, oh, gee, shucks, I don't know anything about this stuff, and neither do you. And that's not my style, and that's not what I'm going to do. I did the best that I could to, kind of teach the jury the language that the DNA experts were speaking, because that's really the only complex part about it. Once you understand what words they're using and what those words mean, you can follow along with their analysis. And so we tried to do that. Really, though, our part of the case didn't depend on the complex part of the DNA testimony. I mean, as I kind of laid out in my close, the main thing that I wanted to focus on as far as the DNA went was how much foreign DNA there was all over the house, and not just all over the house, in places associated with the commission of the murder. That's why I went through probably a 25 or 30 exhibit list for the jury of all the items that were found to have foreign DNA, including the swabs that were taken or scrapings that were taken from under Ms. Peters' fingernails. So I didn't feel that the jury was lost or that they didn't understand what we were trying to teach them as we went through the DNA. I called, as you saw, multiple Florida Department of Law Enforcement DNA experts who are really excellent at explaining it to a novice. I mean, Joellen Brown took the time to kind of teach me the lingo a decade or so ago when I was a prosecutor. So I knew that she could break it down and simplify it in a manner that the jury would be able to digest.
Yeah, clearly it was a DNA case, and for the defense, that is somewhat unusual, where you really have more DNA on your side than the prosecution. Nathan Prince, defense attorney for Henry Segura, is with me. Can you stick around for just a moment, sir? We're going to take a quick break.
Yes, sir.
I'm going to put you on the spot, yeah. Okay, we're going to take a quick break. We're coming back, more fascinating insight from the defense perspective in the Segura case. Stay there. And welcome back, folks. Michael Bryant here. Good time to join us. Nathan Prince is with me, the lead defense attorney for Henry Segura in the trial just ending out of Florida there. Let me give you a hypothetical, Nathan, because I think this helps me try and track the DNA issue we were just talking about. Let's assume Henry goes to trial. There is no unexplained DNA. There's nothing under the fingernails of Brady Peters. There's nothing on that phone or phone cord in the bedroom. He's convicted. 5 years later, through whatever reason, DNA is found. And remember, this is a 2010 case, so it wasn't as sophisticated as now. So 5 years later, we find that DNA under the fingernails. We find that DNA on the phone cord. Is there any doubt in your mind the Innocence Project or a similar organization will be taking up this cause?
I mean, we've discussed that exact hypothetical amongst ourselves in the past, that this is one of those cases where before I got involved, it really hadn't been developed to that point. But we got involved in time to properly develop it, get our own experts, spend time deposing the state experts. I deposed Jason Bundy for probably 12 hours over 2 different depositions during the course of this case. And we're able to bring that all out ahead of time instead of having to go back in a post-conviction setting and do it that way. So yes, we've talked about that many times throughout the pendency of this case, that it looks like one of those Innocent Project cases where somebody gets saved after they're already on death row.
Yeah, it doesn't help explain it. It makes it maybe more head-scratching. Let me ask you about 2 witnesses, neither of whom we heard from, because one may become an issue on appeal. The hairdresser, the one who was there ostensibly to suggest that Mr. Segura knew what he knew through her. The judge said, no, she's not going to testify. Thoughts on that?
Yeah, I mean, that was a tactical move by the prosecution. And if the goal is to win for them, then there was a smart move. They waited until we had closed our case in chief to put on evidence indicating that information, that is to say, information about the nature of the victim's deaths, wasn't shared or proliferated on the day the bodies were found. The reality is that that's simply untrue. That testimony was simply untrue. I could have, in retrospect, if I knew they were going to claim that, I could have called 30 or 40 witnesses to say that they all knew about that on the day that the victims were found. So the reason I wanted to call just Miss Douglas in response was because she was the person who had actually told Mr. Segura on the day the bodies were found what had happened and how the bodies were discovered and what the nature of cause and of death was. So
assuming an appeal, is that going to be one of the issues you bring up?
Yes, that'll be one of the issues that we raise.
Let me ask you, before we get to the appeal, and I want to ask you just a couple more questions. What the heck was the deal with Gregory Washington?
This is probably too short of a segment to discuss all that. The long and short of it was that because he wasn't compelled to testify, I had to make a difficult decision between trying to extract part of his testimony through Lieutenant Basio, who I knew would testify truthfully, and playing his former testimony from the last trial, where he was just a loose cannon. I mean, a loose cannon to the point where I didn't want to play it, and neither did the state. So it was a difficult decision to make. We were damned if we did, damned if we didn't, and we had to make the choice that seemed best to us under the circumstances with limited time to decide.
So and everybody wondered, okay, maybe he's being called. He's not going to testify, but that makes him unavailable. We can use his old testimony. But for what you're saying, the guy was just a little too wild, and it would have been harmful maybe for everybody for him to have testified via his first appearance. I get that, but it was a question everybody was asking. Another question that folks have asked is, this was in 2010. The first trial was 7 years later, and this one 2 years after that. Why the delay? Why so long? I know you were lead counsel in the second trial. You were second chair in the first, but you've been there for the whole ride.
Well, I didn't come on board until 2015. And so once I got involved, Mr. Segura asked that I get involved after the first major Brady violation was discovered. No one knew until 2015 that there had been a CODIS hit on Angel Avila. And so when the state attorney's office found out about that and revealed that, Mr. Segura brought me on board at that point. I was I was the lead trial attorney in the first trial, lead trial attorney in the second trial. So for most of the substantive parts of the process, I was there and, kind of leading the way. So, I've said that there's probably nobody in the world more familiar with the facts of this case than I am. But at the end, with this particular jury, that didn't end up mattering.
Yeah. Final question here for you. Obviously, life without parole is a win when you get to that point. How's Mr. Segura doing? What was the idea to just kind of lay down on the penalty phase? And what do you see going forward in terms of the appeal?
Yeah, Mr. Segura wanted a death verdict, not because he wants to die, but because he thought that would give him more meaningful review. And I don't think it would be appropriate for me to go more into detail than I did on the record regarding that issue, but that was the strategy there. As you probably know, people with death sentences get appointed representation all the way through every step of the appellate process, from direct appeal to post-conviction to federal habeas. They'll have representation appointed throughout the entire process. So Mr. Segura has never wanted to avoid a death sentence, and avoiding a death sentence was not considered a win by any of us, by any stretch of the imagination. He wanted to go home, and we wanted to bring him home, and that's still the goal now.
You think he's innocent?
I know he's innocent. I wouldn't have taken his case if he was guilty.
Great. Nathan Prince, thank you so much for the observations, the insight. Great work there. I'm not kidding you when I tell you everybody was really appreciative of the time, effort, and presentation you put on for Mr. Segura. So best of luck on the appeal and everything else going forward.
Thank you, sir. I appreciate it.
You bet. Take care. Okay, guys, we're going to take a quick break. Again, Nathan Prince, defense attorney for Henry Segura. We'll come back. We've got the case against Mark Sievers underway. They're on a break right now. We'll catch up with everything when we come back. This is Law&Crime.